streamed.
Okay. Do I need to wait, Your Honor?
Yeah, why don't you wait until he's got it on live stream?
The case is now being recorded.
You're all set now.
Thank you, Your Honor. Thank you. I appreciate that you've read as much of the record as you could. I actually spent the weekend doing a fair bit of that myself. There's no question the pleadings are long, Your Honor, but at the end of the day, there's a lot that's agreed to between the parties, and the issue that the trial court would be presented with is really pretty narrow. All the parties agree that my client has a disability. All the parties agree that my client has done everything DCF has asked her to do. All the parties agree that my client has gotten services on her own. All the parties agree that my client has, on the advice of the court's own clinician and my client's expert evaluator, asked DCF to tailor services to her particular learning style so that she could implement in real time, in real life with her sons, the information she has learned from parenting classes and the parent aid. And everyone agrees that DCF has not given her that. So really the narrow issue for the trial court is DCF's failure to offer services that are tailored to the mother's particular learning style so that she could in fact benefit from them. Is that failure a failure to make reasonable efforts, or is it enough that DCF has offered them the same kinds of services they would offer to a parent who does not have these particular needs? So I don't think at that this hearing really should take a whole lot of time. I understand, again, the motion was really long. In fairness, counsel had just learned from the SJC that number one, she could bring this kind of motion, and number two, that she had a burden of production. So, but at the end of the day, the parties agree on much more than they disagree about, and a hearing should not take a particularly long amount of time.
As DCF pointed out in their opposition today, a lot of those arguments, I think you're acknowledging that, really weren't made in that form to the trial court a few weeks ago. Let me ask you this. What is it that your client and the children, I'm going to ask the same question to the children, will benefit from having a hearing, say, in the next week or two, as opposed to in 75 days from now?
They will, if the trial court makes the determination that the mother and the children agree that the trial court should make, that DCF has failed to make reasonable efforts, then the court can order DCF to take remedial steps to provide the services that the mother needs in order to.
What is it that you think can happen in the next 70? Let's assume that the judge orders what you're looking for. What is it that you think you can gain from the 75 days?
That the mother will be able to more clearly implement what she has learned in her interaction with the children.
I mean, like what? So the way I think about it is this, and maybe I'm thinking about it wrong, but the judge has said, I'm going to have a trial, and I'm basically going to have a continuous trial, an unusual trial for the juvenile court, starting on January 31st. So what you're asking me to do is intervene and tell the judge, even though you're going to have a trial in 75 days, there's such urgency to this that you should have the trial now.
Because, Your Honor,
deciding that reasonable efforts have not been taken is not the answer. The answer has to be, I will get A and B and C now, and that's going to make a difference in the trial 75 days from now.
That's exactly it. That's exactly it. She will get the services that she needs.
What services will actually make a difference in the next 75 days? And how?
This mother, once DCF has finally given her things she's asked for in the past, she has had an almost immediate improvement in her ability to interact with the children, reports of visits, all those things. If those things continue for 75 days, DCF is going to have a heck of a time proving that the mother's rights should be terminated in 75 days.
What services will make that difference? What is it that you want her to get?
The parenting coach, who is, giving her real-time feedback, which is something that she needs. Additional time with the children to hands-on, use the skills that she's been taught, which is something that is said that she needs. I don't remember all of the things, I apologize, that she asked for.
Family therapy.
family therapy, which she's got now with one. So she and her husband are doing therapy together with one of the children. There are problems in the children's relationship. And she's looking for family therapy, the whole of them together, doing therapy together, and family time that allows her to implement what she's learned. You're right. I have to say this notion that, the trial's only 3 months hence, and the court shouldn't have to make a reasonable efforts determination twice in the span of 3 months. That's exactly how the statute is designed. The statute says you have to make a reasonable effort.
Says no less than annually. And is it accurate that there was a reasonable efforts determination unobjected to? I believe it was September of 2020.
Okay, if I'm going to answer that, but I just have to get this out because, Your Honor, the statute contemplates a 3-month. It contemplates a 29B hearing, reasonable efforts determination, and then it requires a reasonable efforts determination at trial, which must be held 3 months later. So the 29B hearing has to be held 12 months from the filing of the petition. The trial has to happen 15 months after the filing of the petition. That's 3 months. So the statute is in fact designed for reasonable efforts determinations to be made 3 months separated. This notion that my client didn't object to the reasonable efforts determination, there is nothing in the record that supports that. My sister for the department points to the docket entries showing that a permanency hearing was held.
Was it objected to? So is it accurate? But you have to answer my questions. Was there a reasonable efforts determination made roughly a year ago, September of 2020?
It was made on September 29th, 2020. I do not know what happened at that hearing.
Okay, you weren't representing the mother at the time. It was a different lawyer who had been representing her for quite a while, as I understood it, right?
She had only been the mother had been represented by a CPCS office attorney for a couple of years, and a new attorney in that office had come on. I don't know that exact date, but it was actually after the permanency hearing.
But there was no appeal. There was nothing at that time that suggested the kind of disagreement that I have in front of me now.
Absolutely not true, Your Honor. There had been, the mother had filed her in April of 2019, had filed the motion for a determination for a ADA compliant services, and she made a lengthy reasonable efforts argument in that pleading. And then she raised, just after the permanency hearing, she raised it a few months after in a motion requiring DCF to provide services. I mean, she tried to get at it a whole bunch of ways. And
right, but there was no appeal, was really what I was, but you're right to point that out. But there was no appeal from a reasonable efforts determination made a year ago.
No, and I'll tell you why. It takes a year, Your Honor. A determination of reasonable effort.
Not if you do what you're doing right now, counsel. That doesn't take a year. It takes a week.
But you can't, Your Honor, because a reasonable efforts determination made under 29B by statute, an appeal from that has to go through the ordinary. It's treated like a final judgment. It's an appeal from a final judgment. So I don't think we'd even be here if she had applied. If she had appealed under that.
There's got to be a way, a stay pending appeal. There's got to be a way to get in front of a single justice right away if it's got the kind of urgency to it that you are indicating this one does. Let me move on, and I'll come back, and you'll certainly get your opportunity to be heard. Which of the, why don't we start with the older, by the way, how old is mother?
I don't know. If someone has the docket, I don't know, Your Honor.
She was born in '89. So
thank you.
She's 32. She was 24 when she had the first of these children then? Okay. Why don't we go with the older of the children who I believe, well, we don't use names.
Oh, that's right. Yes. For the older child, Your Honor, yes, I apologize. I think I said his name earlier when we weren't on the record yet. So he is 8 years old, Your Honor. He's been living in a group home for the past 2 years. I do not represent him in the trial court, but his trial attorney was able to set up a Google Meet. And I was able to speak with him. He told me that he wants me to tell the court that he wants to go home to his mother. And if not to his mother, then he wants to be adopted, that he's been, to quote him, "I've been in here for too long." And from my understanding, mother is just seeking certain services so that within, the 75 days before trial, her sons can hopefully come home to her and certain services can be implemented so that any type of reunification process could be possible and could be done safely.
So child supports mother's petition.
Yes. Sorry.
Child supports the desire to have a hearing immediately with respect to reasonable efforts. What does child think has been missing with respect to reasonable efforts so far?
Well, I think what has been missing, Your Honor, is that the visits with his mother, they're only held weekly, and there has not been an opportunity for him to go
They're
home.
not weekly, they're bi-weekly, as I understand.
Bi-weekly, Your
right
Honor.
now.
Right, and they're not. They're only for an hour or two. So and then they're held in I asked him how her visit's going with her mom, and he says they're held, in this like room, and that's it. So there's no overnights. There's no way for him to continue to expand on the time with his mother, which would be very helpful to do. A lot could be accomplished in 75 days if the visits were expanded, maybe if they were in a different location.
Are they supervised visits, do you know?
Yes, they're supervised by the department.
Okay. I'll come back. I'll hear whatever anybody else wants to say. At some point, I'm going to have to end this, but I have more questions. Attorney Foster, what about the other child? What's the other child's position?
The younger child is 7 years old, and he has been in a residential care facility for almost a year now, and he's miserable where he is. And as much as he's able to articulate his position, he is miserable and he wants to go home to his mom. He wants to be in his family. The benefit to him of a parenting coach and additional time with his mom, which is what he would be seeking, is that he would be able to start to rebuild some of what was broken in his relationship with his mom and maybe even his brother. He has no family right now, but he knows his family and he wants to be with his family. This is the only way that this will happen is with this help from mom. It's this situation, Your Honor, is really identical in some ways to the situation that resulted in the 2015 letter to the Massachusetts DCF. In that situation, the mother was denied hands-on parenting help during visits and instead was judged on her ability to independently, without those tailored services, parent her children. I mean, my client is a child who the department, when they removed him earlier in life, placed him with a foster parent who specialized in experienced foster parent who specialized in medically needy children. And given that the department has acknowledged that about my client, the failure to help mother in this very simple way is seems even more egregious, since that's really all that she's asking for at this point, because that's really what she needs. I would also point out, Your Honor, with regard to the failure to object to the reasonable efforts determinations, that the court has never actually agreed with DCF's goal. At both the October 30th, 2019 and September 29th, 2020 permanency hearings, the court found reasonable efforts, but based on the court's goal of reunification, which I'm not sure how the court reached that conclusion that reasonable efforts were made towards reunification when the department was seeking termination and adoption. But that's actually what happened in both cases. So, and to the extent that that informs why the mother and the children might not have appealed a determination that actually agreed with their goal, it at least is somewhat explanatory, if not also confusing that the judge would come
Except
to
that
that.
reasonable efforts, as counsel for the mother pointed out, reasonable efforts has been the issue all along, since at least April 2019. What's the department's position?
Well, good morning, Your Honor. All these issues will be reviewed by the court in full in less than 3 months at this point. All these issues that mother and the children are raising, they can put on all this evidence and they can even ask for this to be heard initially. A mother had quite an extensive witness list. This is going to be a very lengthy hearing. But as I say, there's no reason that this couldn't be the first issue the court considers. The court has to consider whether the department made reasonable efforts to reunify.
But there are two different things. One is, did the department make reasonable efforts? The other is there something in the next 75 days that could make a difference in the outcome of trial?
Yes, that would be
Right?
very unlikely.
But why do you say that? I mean, but I have 3 lawyers here who say this is an unusual situation. Mom is in need of help, and she's in need of parenting time with help. And if she gets that, things improve. Why do we just decide that that's unlikely? Well, let me ask you this. Let's get down to some nuts and bolts. Why can't the department do weekly visits?
I believe that we are offering weekly visits. I thought in mother's submissions, there was indication that we have been providing weekly visits.
You had
just
up through
maybe in the
August of
past.
2021, at which point somebody decided it was too hard to get one of the children to the visits, and you started doing them bi-weekly. And you changed them from where they had been. Go ahead.
Right. Well, but again, these issues can be addressed in full during the trial on the merits, which will be held in 2.5.
Counsel. I think that is a very simplistic answer to what these 3 lawyers are telling me. Wait 75 days and we'll take a look at it. I don't think that there's any coincidence to the fact that this reasonable efforts motion was filed 2 weeks or within weeks after the change that the children went to bi-weekly instead of weekly. Mom's saying, I need family time. I need to spend time with my children. When I do, I think things will improve. And DCF is saying,
But
I can't get the kid there?
this was a motion, mother's motion was 30 pages long, including, this was a reasonable efforts motion. This wasn't a motion for abuse of discretion on visits. That's not what mother filed in this case. She filed a 30-page extensive memo with a bunch of different services. Many of these services overlap or are trying to be put in place by the department. COVID has caused a number of disruptions, not only to the trial court's calendar, but to the services to provide services, has hampered our ability to provide services. And that's also in mother's submissions. If mother was really concerned and the children were really concerned about visits, they should have filed a motion for abuse of discretion on visits only. And at that point, the judge could have heard that limited motion, but that's not what was before the court.
Hold on for 1 second. Mother's counsel, what do you say to that?
First of all, there's nothing, it's never been established that abuse of discretion is the proper standard of review for a request for visits. So that,
No, it's an abuse of discretion motion. That's what Rashida says you do if you're directed at a particular aspect of the services that are being provided.
Assuming visits are a service, which the law is fuzzy on that. So there's,
I see.
yeah. So, mother could have filed a shorter motion, I guess. But again, mother only, everyone learned only in August of this year that it was okay to bring these kinds of motions. And everyone learned that there was an initial burden of production. I just wanted to correct something my sister just said. And she says for the department in her memo that the mother is going to call between 15 and 20 witnesses at the motion hearing. That's incorrect. That's what the judge said could happen at trial. There could be as many as 20 witnesses at trial. And he said several witnesses at the motion hearing. And as I boiled down for you, Your Honor, at the beginning, what really is agreed to in this case and what is in dispute. And I know Your Honor felt that issue, those things weren't raised in the motion. They were raised in the motion. They were just raised with a lot of words. It wasn't bottom lined in the motion. And that's a regret, but that doesn't change the fact that the court could dispose of this motion very quickly if he asked, the part or ordered the parties to file stipulations of fact, because again, pretty much.
Did you file the motion? Is it your motion, Attorney O'Connor? I can't see a signature page on it.
Which motion?
The reasonable efforts motion that was filed in October, which I have in front of me.
That was the trial lawyer for the mother, Your Honor.
Okay. Who's not on the line, I take it.
No, Your Honor. May I also point out, Judge, Your Honor, there's no reason that this trial has to be held in January. This case is within the time required by statute.
Now, do you want to delay the trial?
If it
that sounds to me tactical. That sounds entirely tactical. It's like I want to avoid a final decision while I change some things about where mom is in advance of that.
I think it's, Your Honor, it's true to the legal principles that these issues have to be decided early so that there will not need to be a trial. The goal here is, and it's the court's plan, is reunification. The goal is to get this family back together if that can be done safely. And the mother's been denied these accommodations since April of 2019 is when she started asking for them. So the department's been delay. And now they want to delay until, after.
Delay on reasonable efforts, but not on trial. Trial delay is what mom wants.
No, Your Honor, what the mother wants.
Well, I thought you were just about to ask for that.
What the mother wants, Your Honor, is to get these services in time to make a difference. To get these services now. If the judge finds at trial that DCF failed to make reasonable efforts, and because of that, mother's unfitness is only temporary, and I'm not going to TPR, now I'm going to order DCF to make those efforts. Now we delay the case for another, who knows how
75 days.
No,
I mean, that's all we're talking about, because all we're talking about is when the commencement of the reasonable efforts trial is. You want it to be immediately. The judge has said, I'm going to start on January 31st, and I'm going to go Monday, Tuesday, Wednesday until completed.
That's
which
not
is
a
pretty
reason.
Good for a juvenile court. I mean, in terms of the schedule.
I'm sorry, Your Honor, I don't understand. There's not a reasonable efforts trial. You mean the hearing on the motion?
Reasonable efforts will be part of the trial. That's what the judge said. And of course, that's right, isn't it?
Reasonable efforts has to be.
I mean, it's part of the determination. The department is going to say that the mother's unfit. You're going to say mother's not unfit at all. And if there's any unfitness, it's temporary. And so you can't order the mother to be found. You can't terminate parental rights. And as part of that, judge is going to, and you're going to argue, and by the way, they didn't make reasonable efforts. And that's part of the reason that you can't determine that she's unfit. And that's all going to happen in 75 days.
Then we wasted 75 days, Judge. And
that's why I started with the question. Counsel, I think I got it now. That's why I started with the question. What are you going to get out of the next 75 days? And I have to say, I would find it frustrating if I were the mother and I had weekly visits with my children, and I think they were not in the DCF office. And then DCF said, for a reason that can't be articulated by counsel, she doesn't know why. You know what? We're going to do it once every 2 weeks now, and we're going to do it in our offices, which the children don't like, and it sounds pretty structured. But the response from DCF's counsel was, well, you could have filed that as a separate motion, and your response about that is to say, well, we kind of really didn't know until just before this was filed that we could even file one of these, and so we filed a very comprehensive thing. And I kind of get all that, but it's in my lap. And there's a judge who's known about this case for 3 years and has said, I'm going to dedicate trial to this starting January 31st. So for me, the question is, what can be gained in the next 75 days? Frankly, I think that you guys ought to have a discussion, and I'm not sure you've got the right people on the phone, about whether there's a way to provide the mother and the children with better family time for the next 75 days. That, it seems to me, is something that might make a difference in terms of the kind of testimony that the judge took at trial starting on January 31st. It might not, but it might. In addition, we have this issue of whether there's a parenting coach or a parenting aide. I'm no expert on this, guys. It doesn't sound different enough to me to be the kind of thing that I would intervene in for that kind of period. But there are some things that you say that make sense to me. Does it make sense for me to get off the phone or for you guys to get on? I mean, I can get off the line, take myself right out, and you can have a conversation about whether is there any way to get DCF to change the parenting schedule for the next 75 days so that mom gets better parenting time, maybe gets that parenting time, you know, at the local park, or that's going to be hard to do in November and December, but, you know, gets parenting time that's not so structured that the children feel really uncomfortable. Does it make sense to have you guys talk a little bit about those kinds of things?
Your Honor,
Because if mom's counsel, if I order a hearing now, the judge will do his or her best. Is it a he or a she? I can't recall.
He.
Will do his
Judge
best
Johnson.
to try to plug it in, but you know, there's no guarantee that's going to happen quickly. I mean, I can understand the judges. I mean, I think what happened here is the judge was like being pressed to do something and said, you know, I'll do that, but I'm going to do it. I have to have a trial anyway, because trial is what I feel like I need to do. This is an old case. And as you point out, this judge has not yet accepted DCF's proposal for final disposition.
Your Honor, if I may, I don't think that short of an order, DCF will respond. And I think that's evidenced in DCF's email to counsel, where she says, what disability? Are you going to prove this at trial? In kind of a snarky way, even though she's been on the case for the last 3 years and they've had multiple ADA meetings. And
well, how would you articulate what the disability is?
DCF articulated in their opposition. They listed on, I think it's page 11. So I guess we don't just disagree.
Those are ADA-based disabilities?
They all
Mental
are.
health?
They all, there's a panic disorder,
Okay.
there's ADHD, anxiety. Those are all ADA-based disabilities. And counsel should know that, obviously. But I think it really, the question comes down to how are we going to use these disabilities? Are these disabilities a reason for the department to provide clinical services? Or, as in their opposition, are they a reason that the department will rely on to terminate mother's parental rights? I think that first they have to.
So you think there
ADA
needs to be, I'm sorry, let me interrupt for a second. If you think there needs to be an order because you think DCF won't pay attention without an order, basically what you're saying.
Yes, Your Honor.
But the order, my concern is that the order has very little practical value when trial is going to commence in 75 days. I'm looking for practical value. I think there's practical value in specific things that can be delivered in the next 75 days that might make a difference in terms of the evidence presented at trial. That, it seems to me, is the way to think about it. And that, it seems to me, family time, visitation, I get it. That may make a difference because you're going to learn about how mom interacts with the children, how the children are now interacting. Everybody's getting more mature. Everybody's aging, mom and the children. I get that. Parenting coach, parenting aid, I don't know. Beyond that, I'm skeptical that there's much that can be given in the next 75 days.
If I may,
I think that might be enough, Your Honor. I'm sorry, I would just point out that when mother did receive an accommodation, that she was allowed to talk to the therapists of the children. So she talked to them outside of the visits. She brought that information into the visits and the visits drastically improved. And she has been willing to do everything. DCF admits she'll do anything that they ask her to do. They just won't give her what she needs. So I literally—
Does DCF admit that the mom is willing to do anything that they ask her to do? No, I'm asking Attorney Murphy.
She has been cooperative with the services we've been able to put in place.
So it's Attorney Murphy.
And as far as the visits are concerned, I'm sorry, I didn't hear you, Your Honor.
No, go. You're on a delay for some reason. Your your
Oh.
feed is as good as some other people's feeds. That's why we're
Oh,
having
I
a little
apologize.
trouble talking back and forth. So go ahead, finish out what you were going to say.
I was saying that the department would be, I certainly would ask our trial attorney to take another look at the visitation piece. If that's something that could be done, for some reason, I thought we were doing weekly visits. If not, I would absolutely be happy to go back to the trial attorney and investigate that and find out what the reasons are, if any, for having biweekly visits. That's something, I think the visits is the only thing that could be put in place quickly. None of these other specialty services are going to be able to be put in place in any quick time frame.
So that seems to me to be a not unreasonable way of looking at this, based on what I know. This is where, Mama, Attorney O'Connor, I'll give you a moment, but I've got to shut this down in a few minutes. I will give you all the opportunity to talk before I enter an order, which I will enter. It may not be as quickly as people want, but I'll enter one. Report back to me on whether you've been able to make progress with respect to those things. I'm thinking in particular about visitation and family time over the next 75 days. Is there, Attorney O'Connor, you wanted to speak. Is there anything else you want to make sure you talk about, or you call to my attention and say, we really need this too?
I think it sounds like you already know what I was going to tell you, which was that you can enter the remedial orders yourself. That's what Justice Carhart did in Walt, and that's what the SJC affirmed. So you have the same equitable authority that the juvenile court has, according to Care and Protection of Walt. It sounds like you know that.
Actually, no, that wasn't what I was thinking. But how do I do that? I mean, I would have, wouldn't I have to? I'd have to have DCF people here who can talk about what they're. For some reason, there's difficulty getting one of the children to these meetings. That's a practical problem that I don't think even the people on the phone can answer. What you're capable of, what DCF is capable of doing.
The other thing I wanted to mention, Your Honor, is the distinction between a parent aide and a parenting coach. And it is discussed quite a bit in the very lengthy attachments to the motion, but like basically bottom line is what was recommended for mother was a person with particular credentials who would go to visits with mother and help her incorporate what she learned in parenting classes, give her
Attorney Murphy, why can't she have a parenting coach instead of a parenting aide?
Again, I think the COVID situation has made putting these services in place very difficult. In fact, the mother submissions show during the foster care team review that this was a huge problem. Trying to get everybody, all these services, very specialty services that mother's looking for here. Well, the department has been working with mother and put a number of services in place.
That I understand. I get that. And I get the fact that the children went back to mother and that it didn't work out and that they had to take the children away. This has been a lengthy and difficult process on all sides. But mother's getting older. She's getting more mature. She seems to be doing her services now. She seems to be responding to what she's being asked to do. And an answer that says, well, COVID, we can't find a parenting coach is, I guess the department can take the position. They made reasonable efforts, and reasonable efforts were not enough to get mom a parenting coach. I don't know. I can't resolve it right now, but it sure would be easier if a parenting coach could be made available, if the children's sessions could be once a week, if the children could do it someplace that was more conducive to family organization. I'm going to take this under advisement. I'm going to suggest that you guys talk. And Attorney Murphy, it sounds to me like you need to get back to your client. I'm going to suggest that you guys talk about what can and can't be done. I don't know how I'm going to decide this. I don't think it's easy. Okay. All of you have an incentive to avoid an order that isn't going to help one side or the other in a way that's not right. So if you could talk, that would be wonderful. I will take it under advisement. Anything anybody else wants to tell me before we're done?
Sorry, Your Honor. I just have to, just as a
Oh,
caution.
Your Honor,
No,
I'll
sorry.
get Attorney Murphy, you'll get the last word.
The SJC in Rashida did not even suggest that it would be appropriate to continue a reasonable efforts determination to the time of trial. Quite the opposite. They talked a lot about the established principles that these issues have to be raised and decided early in a case. And they did say it would be possible maybe to put it out to a 29B hearing because those are actually identical issues. The issues for trial include reasonable efforts, but those aren't, the reason for the issue, for the trial. If Your Honor, if this court issues a decision saying it's not an abuse of discretion for a trial judge to continue a reasonable efforts motion to the time of trial, that's going to spread through the juvenile court.
I guarantee you that that's not what it's going to say, counsel.
Thank you.
It is going to be tailored to the specific facts of this case, the specific motion that was filed, which you admit indicated potentially a lengthy evidentiary type hearing that would in a lot of ways mirror trial. So that's the way the judge took it. And I'm not sure he was wrong based on the motion that I'm looking at. You're now giving a slightly different motion to me.
I'm condensing
You're
what's
saying,
there.
well,
I'm
but
condensing
okay.
what's there.
Okay, but what you were doing basically was saying to me, don't say X. And I'm telling you, I'm not going to say X.
Thank
Okay?
you. Thank you.
All right. I don't disagree with your fundamental point. I'm trying to be practical here. And also I have a consideration of telling a judge that the judge has to do something that wasn't really presented to the judge in the first instance. Okay. And so I'm trying to balance all that. I'm just saying to you, it would be great if you guys could work this out, because it sounds, I'm not saying that what you're presenting is without merit. It sounds to me like at least some of what you're presenting has merit. Attorney Murphy, last word.
yes, thank you, Your Honor. I would just remind you that did the court abuse his discretion here? This is really the only issue before you. Did the court abuse his discretion? The other problem is we don't have the facts in this case. We have a bunch of submissions by mother. The facts will be revealed at the hearing. This is a very complicated case with years of services, very complex needs on mother's part, very complex needs on children's part. If the department, this issue could be addressed immediately, right when trial begins. And if the department's efforts are deemed deficient, then that's what the court will determine. And then the court would be in the best position.
Isn't mom
to
right
make
that means
kind
that's 75 days later?
Yes, that's right. And it's actually only 2.5 months.
But
at
aren't
this
they
point.
also right that Rashida suggests that time is of the essence in the delivery of service?
But Rashida doesn't say you could never postpone a hearing of reasonable efforts, particularly in this case.
But now you see, you're both argued law to me, and I'm trying to be practical. Okay, you both went right to the law and argued law. I get the law. I'm just trying to. I mean, why can't they see each other once a week? That's all I'm asking. So
well,
I'm going to take it under. I understand the point on both sides at this point. You've been great. This is a very well done argument on all sides by all counsel, and I'll take it under advisement. I will issue an order. If you can make that order easier and make things better for the family in the meantime, that would be terrific.